Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about unreasonable delay in administrative proceedings. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Duchesneau was a podiatrist who was facing some administrative proceedings under the Civil Code of Quebec, and part of his administrative proceedings involved him having to deal with time periods during which the hearings and the applications and the trial ultimately took place. And the judge based the calculation of Mr. Duchesneau's argument about how long the entire process took and whether it was unreasonable delay on minutes. Transcripts were listened to and calculated down to the very minute to determine whether or not something fell over or under the presumptive 18-month ceiling. And as a result of that, the court ultimately determined that Mr. Duchesneau's right to be tried within a reasonable time was not violated. This case raises very important issues because although we've had guidance from the Supreme Court of Canada in Jordan and Cody, where cases fall very close to that 18-month mark, is it appropriate to calculate the exact number of minutes that transpire? And Mr. Duchesneau was also self-represented. And oftentimes when he was asked questions about whether or not he was waiving delay or whether he was acquiescing to periods of delay, he remained silent or he said, yes, I'm okay with that, without being informed on the record or by anybody in any evidence that was led about the consequences of that to his ultimate application on delay. So the court was also asked to consider whether acceptance of delay or silence in the face of delay amounted to acquiescence and amounted to consenting to the delay in the same way that we're supposed to consider clear and unequivocal waivers of delay only as being sufficient to amount to a consent to a particular period of delay. This case has significant implication for the calculation of delay and the fine little precision work that courts have to do in determining whether there is too much delay or not enough delay. And the idea of calculating something down to minutes could lead to absurd consequences. If it's 18 months and 60 seconds, does that ultimately mean that the delay is unreasonable? And where do minutes factor in when you'll have dates that are months and months apart, or a trial that starts at 10:30 because there's a couple bail hearings that have to take place at the beginning of court at 9:30? When we start to calculate minute by minute in courts that only sit set hours in British Columbia 9:30 to 4:30, then doesn't the issue of minutes become a little bit absurd? And wouldn't it be strange to stay proceedings in a serious trial against somebody charged with very significant offenses where the Crown case is strong on the basis of the fact that it was 18 months and 5 minutes as opposed to 17 months and 364 days and 59 minutes? These types of calculations seem to be a little bit contrary to the spirit of what the Supreme Court of Canada talked about in Jordan. And they had an opportunity to breathe life into the real issues of delay and the calculation of time periods and what happens when you're standing in a courtroom and other matters are heard ahead of yours and your trial starts late. And unfortunately, the Supreme Court of Canada failed to give life to any of these issues, failed to consider any of these issues, and left us answering questions about whether or not 6 minutes of court time was effectively used or whether or not the defense request to take an early afternoon break to consider an unusual answer in cross-examination amounts to defense delay. What a world. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you to Unreasonable Creative for putting together these videos. Please like, subscribe, and share with your friends. My producer has informed me that my math sucks, and that's why I'm a criminal lawyer, okay? We don't do math.